About revision petition allowed.
Obliged.
Petition allowed.
Obliged.
Petition dismissed.
In regard to item number 32 of today's list, my lord, which is the last hearing matter, I am appearing for respond number 4. My lord, there is some urgency in this case. My learned friend appeared for the petitioner. May I make one out of turn prayer, matter? Can this matter be taken up at 2 o'clock? My client is suspended since 2021, and there is a matter before the educational tribunal where she is the appellate. The matter pertains to an order which is assailed, in which some documents were called for. That matter has been stayed since then, and she is still under suspension. In fact, she has been removed in the course of time. May I pray this matter be taken up at 2 o'clock, subject to the convenience of this court? My learned friend for the
other side.
the petitioner's counsel is here.
Any objection?
No.
At 2 o'clock. Deeply obliged.
May I so I'm praying for listing of a metal also. Next week was it possible
No.
or Monday or Tuesday also? Agency
They
or Tuesday also.
Tuesday.
Obliged.
May please, your lordship. My lord, these items may be listed, my lord, next week. When I've given the date, my lord, Wednesday and Friday. Next week. So 5 items. My lord, 2 I have given.
Not two different dates.
My lord,
You
2.
take a date from him. Yes,
May able to mention listing a matter next week, my lord, admission matter, my lord.
next week.
Next week. All right.
May it please, my lord. Prayer for listing of a motion matter for tomorrow. Termination from service.
Tomorrow.
I am deeply obliged.
My lord, it's for motion, my lord. We released it on 22nd.
Second.
Second. May please, your lordship, item number 29, my lord, hearing matter, my lord. I'm for the respondent, Borderland University, my lord. I've taken consent from the petitioner, my lord. After 2 weeks, my lord, it may come, my lord.
After 2 weeks. Third,
VK Borua, my lord. Come.
PK Borua. Learned counsel for the vacancy.
Borderland University, my lord.
No, yes, Borderland University. The other side. Rest for the matter after 2 weeks.
I love that.
There.
May it please, your lordship. Lordship, I beg to mention item number 19, lord. Here I am the petitioner. I have taken the consent from the respondent. Respondent, lordship. Let matter may come after 3 weeks. I need to file one additional.
After 3 weeks.
Yes, sir. Additional affidavit, lordship. So
That's not learned counsel for the other side. Rest matter after 3
lordship, interim order is there.
order passed.
May it
Obliged.
please. Lordship, item number 13, lordship. Your lordship was directed to produce that original select list, lordship. So, lordship, I have taken consent from my learned.
Agreed by learned advocates of both the parties. Place the
After
matter
10
on
days, lordship. After 10 days.
after 10 days.
Lordship. On 5th,
Where
5th of September. 5th September.
Fifth.
At 9. Okay.
Prayer for listing a contempt matter, lordship. The lordship, for order, lordship. 21 or 22, lordship.
Your lordship, I beg to mention item number 33 of today's list. I am appearing on behalf of Mr. N. Jha for respondent number 3. We have taken the consent, your lordship.
Sir?
N. Jha. I'm MBD, your lordship. My name is not reflecting
learned
there.
counsel appearing on behalf of Mr.
N. Jha
N. Jha.
for
Learned
respondent number.
counsel for the respondent number 3 with consent from the other side, respond the matter after
1 week.
after 1 week.
Item number 7. In this case, respondent number 3 filed a affidavit in opposition and we filed a reply after 2 weeks, my lords.
Item number 7.
7.
The prayer being made by Mr. N. Islam,
And is the
Attorney for the the matter is then adjourned to be listed after 2 weeks.
obliged.
May I praise the Lordship? Lordship, I pray for listing of a requisition for admission on Friday, Lordship.
Friday.
Lordship,
Obliged,
prior for listing for admission, Lordship. That is,
Why?
if my appointment is put under challenge, I'm working as a chowkidar in the Dindral Upadhyay
When
college.
do you want?
Matter is about 27 to 26. Lord. Any other date instead of first? Lordship.
May it please your lordship, I beg to mention item number 21. Here is, I have filed an interlocutory application, your lordship, that was not tagged in the main petition. So,
Okay.
master of life.
May I please your lordship, therefore listing two matters, lordship, admission matter. Matter relating one lordship,
When do you want?
pension matter, and one lordship. Oh, lordship, the 21, 22.
Check it from
Before first one. 27.
May please your lordship, I want to mention regarding listing of two pension matter, and here both the petitioners are not getting pension since 2019, lordship.
when do you want?
So any day for admission, listing for admission next Monday, this Monday. Lordship, last week of August will also do, lordship. But they are not getting pension since 2019, lordship.
How many matters?
Sorry,
One matter or two matters?
two matters, lordship.
One in the month of August and the other in the month of
Bless you.
Please, your lordship. Lordship, here the petitioner was appointed under the provisions of PF of the regulation 1951, my lord, and she was working as a assistant professor in GIS under the Department of Computer Science and Information Technology. My lord, what happened, my lord? My lord, kindly turn to page 17, my lord, annexure 1, my lord. This is the total copy of the Honorable Chief Minister of Assam. The cabinet has taken a decision to make the appointment of those persons who were working as the part-time faculties in the various engineering colleges, government engineering colleges and polytechnics in Assam, my lord. And total 451 faculties has been converted to TF, my lord. That is at page 17. And the meeting of the minutes of the meeting, lordship will find at next page, at page 18, my lord.
Mr. Borgo in connection. Matter perhaps their first matter or third. In connection, matter we have passed some order.
My lord, in my case is that, my lord, in this case, my lord, my post has not been during the period of the TF service, my lord. My post has not been advertised. As per the office memorandum, kindly turn, my lord. One thing, my lord, I just draw your attention, my lord. While the appointment has been made, my lord, this appointment has been made under the provisions of the office memorandum, personnel department, 2001 and 2015, my lord. As per the office memorandum, my lord, while the initial appointment has been made during the service period within the 1 month, my lord, the post may be advertised for regular appointment. That has not been done, my lord. And my lord, according to the office memorandum 2015, my lord, I am entitled to get the two extensions, 4 months and 4 months, my lord. Since my post has not been advertised, there is no initiative has been taken by the department to fill up my post by regular appointment, and then I am entitled to get the extension, my lord. That is at lordship fine at page 32 of office memorandum dated 29th October 2001, my lord. Kindly turn to this page, my lord.
Yes.
serial number 2 and 4, my lord, in that office memorandum. Two and 4, my lord. In every cases, ad hoc appointment, it shall be based on the departmental selection process, involving issue of the proper advertisement, giving reasonable time and inviting candidates from the eligibility candidates. This case can, the case of candidate for ad hoc appointment shall not be considered merely on the basis of the
Which
of an
point you are
application.
reading?
Lordship,
Which point you are reading?
I am reading the point number 2 and important point number 2 and 4, my lord. In 4, it is clearly stated that immediately after issuance of the order of ad hoc appointment, the process for regular
Page
appointment
number
shall be
34 is the annexer 10.
annexer 10. Annexer 10 is followed by annexer 9, my lord. In this annexer, my lord, this is the office memorandum of 2015, my lord. 16 March 2015, my lord.
Yes.
In that, my lord, in the bottom, my lord, there is a 3 points, my lord. That Roman 3, my lord. Bottom one. Any fresh appointment made under regulation 3F after issuance of this OM shall get only 2 extension of the term, and then their service shall stand automatically terminated. Personnel B department shall communicate the date of its termination while allowing the extension of the second term. Here, my lord, I am working only for 1 term, my lord. First and second extension is pending, my lord. Here, my lord, till that, my lord, no, my post has not been advertised. In between, my lord, one advertisement was published, 2 advertisements was published. One is for the non-technical, another is for the technical. Lordship will find that at page 26 for the technical, 54 posts has been advertised. There, my post has not been advertised.
Page number?
Page number 26, annexer 7. Advertisement number AESRB 2 2025. Civil engineering 14 posts, mechanical engineering 5 posts, electrical engineering 1 post, chemical engineering 4 posts, instrumentation engineering 1 post, computer application 1 post. My post is computer science and information technology. That is total number of vacant posts 54. My post has not been advertised. And then another advertisement on the same day was published. That is for non-technical. That is at page 29, my lord. There is only 4 posts has been advertised in respect of the mathematics department, my lord. 6 posts, my lord. Total number of vacant posts 6 at page 29. This is for non-technical. Till that, my lord, I am working. But now, my lord, what happened, my lord? My term is going to be over, my lord. As per Annexer 6, my lord, at page 25, my lord. First, my lord, I have been appointed as per the notification dated 22nd January of 25. In the meantime, my lord, my appointment was cancelled. I have approached your lordship, and as per lordship direction, my lord, I have been appointed on 22nd April 2025 for 4 months. For 4 months, the lordship will find that at page 25, Annexer 6.
What is that order?
That order lordship will find at page 25, Annexer 6, by which, my lord, I was appointed.
No, the order passed by this court.
This court, my lord, I have not annexed this order because that has been mentioned in there. This order is that. This is my lordship's order. At page 6.
Now what happened?
Now what happened, my lord? My term, as per this 25, annexure 6, my term will be over on 22nd of April. In the meantime, my lord, the principal verbally, my lord, I have been restrained to work in my service. And during my service period, my lord, my post has not been advertised. As per the office memorandum 2015, my lord, I am entitled to get the extension for 2 periods, 2 terms, my lord. Since I have been appointed fresh after the cabinet decision, my lord. Therefore, my lord, my humble submission before your lordship is that, my lord, since my post has not been advertised till that, my lord, I may be allowed to continue for next 2 terms, my lord. This has been clearly stated in the office memorandum 2015, my lord.
Yes, sir, done.
There is a suppression of facts, my lord, regarding this case. That he is saying that his tenure is still, my lord, there, and he has been working, my lord. Whereas his tenure has been expired on 5th of August, my lord. Because kindly say, I'll show, my lord. Kindly have page number 20, my lord. Page number 20 is the appointment order, wherein all total 17 numbers of candidates has been appointed under 3F, my lord. Page number 20, my lord, subject to discharge. My lord, subject to discharge without assigning any reason thereof, the following persons are appointed temporarily as so and so in the Government Engineering College of Assam as per Regulation 3F of APSC. My lord, I'll keep some lines. Considering their engagement for a period of 4 months as per the aforementioned personnel department OM or till the time of replacement by regular employees, whichever is earlier and posted in the college institutions shown against is with effect from the date of joining. There was, Malad, the initial appointment was 4 months. Then he was terminated, my lord. Annexure 5, page 24, my lord. That this initial appointment was dated 20th of January 2025. This page 20, my lord, which I have already read, my lord. Date is at 23. Below, my lord. This is letter of appointment is 20 January 2025. Then he was terminated on 16 to 2025. That means he was working since my lord, he was working since 22nd of January to 15th of February, my lord. 15th of February. At least he was working 1.5 months, my lord. Then by way of court order, my lord, he has been reinstated, page 24, 5, my lord. In cancellation of this department's notification dated 16 to 2025 as per the order passed by the Honorable Guwahati High Court in so and so. Srimati so and so, Assistant Professor, Department of Computer Science and Information Technology, Jorat Institute of Science and Technology, is hereby allowed to continue her service as per notification dated 22/1/2025, the earlier one, Malad, initial, for a period of 4 months as per the Personnel Department OM. So, at the time of Malad, reinstatement on 22nd of April 2025, he was allowed to continue as per the earlier appointment letter, Malad. And as per that appointment order, Malad, he has already worked 1.5 months. Then the remaining portion will count from here, April 2020, 22nd of April 2025. Since then, my lord, I have already placed one instruction, my lord, as per instruction, my lord. His term has been expired on 5th of August 2025, 4 months. And accordingly, the principal of the said institute has already informed the petitioner that his term is expired and he has been restrained to take classes. Now, my lord, this petition is filed on, after termination, my lord, filed on 11th of August 2025, and here there is no whisper in the petition that he has been restrained to work classes or he is not working there. Rather, it is saying that he is still working in the institute. And his term is going to be over on 24th of August, my lord. And another thing, my lord, this, as my lord has already seen, this PF appointment was done as per the, my lord, cabinet decision. So it was a policy decision to take those ad hoc employees under 3F, my lord. And 3F appointment is initially for 4 months. Now, my learned friend is showing one OM of personnel department, which is at page 34, my lord. Page 34, he is heavily relying upon, my lord, point number 3. He is saying that, my lord, the petitioner case is that he has got a right by way of this provision. What this provision says, my lord, any fresh appointment made under regulation 3F after issue of this OM shall get only 2 extensions for the term, and then their services shall stand automatically terminated. Personnel B department shall communicate the date of termination while allowing the extension of the second term. Now, this point doesn't give him a right to continue or ask for 2 terms extension. This says, my lord, if the government decides or desires to extend those kind of persons under 3F, then this extension can be only for two extensions can be given by the government. It doesn't give him a right to ask for 2 extensions, my lord. Now, what had happened, my lord? Finally, see page 41. Is the, my lord, letter whereby the government released all the 3F appointee appointment under this page 20, my lord, initial appointment, wherein the name of the petitioner is also there. Initial appointment 22/1/2025. It says, as per provision of government notification dated so and so, the government notification, the government in the higher education department hereby releases all faculty appointed in government engineering colleges and polytechnics in Assam under regulation 3F of the Assam Public Service Commission regulation 1951. So, my lord, these by way of this, my lord, notification, all the candidates who were appointed under 3F has been released, and the petitioner has to go there because, my lord, and it is the admitted case of the petitioner that out of this 70 candidates, 69 has been regular. The 69 post has been filled up by regular appointment. Only his post is there, my lord. The government is, my lord, now it is a policy decision of the government to discontinue all those who has been appointed under 3F, my lord, because they are going to fill up by way of regular appointment. This the post of
But his post, her post has not yet been advertised.
not yet been advertised, my lord. I have sought
Then,
instruction.
why this OM dated 16th of March 2020 will not be applicable in our case?
16th of March, my lord.
Yes.
My lord,
Connected then.
my lord, in my humble submission, this OM doesn't give him a right to seek for extension. It is the prerogative of the government how to run the institute and whom to they want to take employment, my lord. My lord, because they are ad hoc appointment, not a regular appointment.
So that's all right.
Now,
Mr. does there is already of
yes, my lord.
why this was then
My lord, what this office memorandum says, my lord, this office memorandum is with respect to, my lord, direction, kind of a direction given to the department that if you, first of all, my lord, you cannot without process appoint ad hoc appointment. If you appoint ad hoc appointment, made ad hoc appointment by a PF, malad, then PF immediately after appointment of PF, malad, the department has to initiate process within a period of 30 days for regular appointment. If the department doesn't do so, and the department desires that the PF appointee has to be continued, then the department can continue those PF appointee only for two terms. It is for the department matter. Now the department thinks that we don't need those the petitioner or the PF appointee, and accordingly release as per the policy decision. Now whether, my lord, this petitioner can ask for that no, going against the policy decision, you appoint me, or even if you don't want the faculty, you appoint me. This kindly have this, my lord, point number 3. This doesn't give, my lord, any right to the petitioner. It says that any fresh appointment made under regulation PF after issue of this OM shall get only 2 extensions. Shall get only 2 extensions. That doesn't it doesn't say that, my lord, he has to get two extension, my lord.
No, the word shall is used there.
Yes, shall, my
not
lord,
me.
shall get only 2 extensions. Only this word only is there, my lord.
Any extension you have given to her.
Extension, my lord, giving extension is
To her.
prerogative of the government. If the government doesn't require that required faculty in an institute, my lord, whether the petitioner can ask for that. That no, even if you don't need faculty, you appoint me. And, my lord, since this is a policy decision, my lord, to engage the ad hoc appointees or contractual, all the contractual employees, the PF, my lord, and as per policy decision only, all the PF appointees has been released, my lord. My humble submission would be this case would not, my lord, interfere with the, my lord, policy decision of the government, my lord, to release and release the petitioner, my lord. And moreover, my lord, as I have already submitted one instruction, my lord, there is a suppression of fact that regarding that he is already still working and his term is going to be over on 24th of August, my lord. His term has already been over on 5th of August, my lord. Because in terms of initial appointment of 22nd of January, he worked for 1.5 months. Thereafter, when pursuant to this court order, my lord, when he was again reinstated, then this period will continue, my lord. Earlier 1.5 months, then, my lord, from April, the other remaining period. 4 months completed on 5th of August. Now he cannot seek extension on the basis of this OM, my lord. It doesn't say give him a right.
My lord, for the time being, my lord, I just want to reply for that, my lord. In the initial appointment on 22nd January 2005, my lord, in the initial appointment, it was clearly stated that in the government engineering colleges of Assam, as lordship, page number lordship will find at page 20. Initial appointment. This is the TF appointment. This entire TF appointment has been made on the basis of the cabinet decision. Cabinet decision is the government policy decision. In this regard, my lord, here my appointment has been made. The personnel department OM related to the appointment under regulation TF of APSC. That means, my lord, while we have been appointed under the provisions of TF on ad hoc appointment, they have followed the office memorandum, my lord. OM. That OM, my lord. In OM, it is clearly stated, 2001, it is clearly stated that within the 1 month of ad hoc appointment, advertisement may be published by department or through APSC. That has not been done. My post has not been yet not advertised. Secondly, my lord, office memorandum 2015 said the person who is working for ad hoc appointment, he or she shall entitled to get the 2 extensions, shall not may, my lord. If it is may, this is the depend upon the department. Department consideration, the question of department consideration come. Here, my lord, it is clearly stated, shall any fresh appointment made under regulation TF after issuance of the OM shall get only 2 extensions of the term and then their service shall stand automatically terminated. Personnel B department shall communicate the date of termination while allowing the extension of the second term. And thirdly, my lord, in the instruction he has submitted on today, 18 August instruction, in the paragraph 5, it is said the service of all other 69 candidates appointed as per the regulation 3F of APSC along with the petitioner by notification dated so and so were not extended further and they were released automatically. Not released automatically, my lord. 41, my lord, of my petition. That is the release order. This notification has been issued. That notification has been issued on 28/5/2025, my lord, in respect of another 69. 41, my lord, annexure 12, my lord. By this notification, other 69s were released from their service. And my lord, their service has been released because their post has been filled up by the regular appointment. Through a process has been initiated, those advertisements were published, interview was held, and regular appointment has been made. There is no any scope for the extension. But in my case, my lord, till that no advertisement has been published, office memorandum say I am entitled to get the 2 extension, they are denied. Entered TF appointment has been made on the basis of the cabinet decision, my lord. Entered cabinet, as per cabinet decision, this appointment has been made. Otherwise, my lord, after publication of the office memorandum 2015, there is no any scope for the department to make any TF appointment or ad hoc appointment. As the cabinet decision is there, therefore, my lord, they have to impede. The cabinet decision is a policy decision and department has nothing to done against that policy decision of the cabinet. Therefore, my lord, our appointment has been made. And this, during my service period as the ad hoc appointment under the provisions of TF, my lord, no advertisement has been made. Now post is laying vacant, my lord. And my lord, office memorandum is said, I am entitled, if post is not advertisement, he is entitled to get the 2 extension of 4 months and 4 months to get only 8 months, my lord. That has been denied, my lord. In the instruction, what he has submitted on today, nothing has been said. Mrs. Devika Deka cannot consider for further extension, which has been expired on 5/8/2025. In the point 5, my lord, last one. Nothing has been explained. Why this is not required? Whether the alternate arrangement has been made? Nothing. Simply say cannot be. My lord, at this stage, my lord, I may be allowed to continue in the light of the office memorandum, my lord. In the light of the office memorandum, I am entitled, my lord, since no advertisement has been made. It is admitted, my lord.
My lord, my humble submission, please. There could have been a case if the government initiate process for appointment appointment for ad hoc appointment, my lord. Initiate process to make ad hoc appointment in his post, my lord. Because government has not made any initiate any process to make ad hoc appointment, contractual appointment. He is working under a contractual appointment, my lord. Now government is not replacing that post by way of contractual appointment. His case is not there because government will fill up this post by way of regular appointment. Second, my lord, page 41, by way of which all the 70 CF candidates were released, my lord. 69. This my lord, by way of this notification, my lord, all the appointed candidates in 22nd of January 2025, they were released. Now, my lord, if he is saying that by way of this notice he has been released, he is not challenging this notification, my lord. And moreover, my lord, my another thing is submission of that there is suppression of facts, my lord, regarding his continuation in the post, my lord. If I go by the petition, my lord, that he is still continuing, then this petition will not lie because he has approached his honorable court with a presumption, my lord. Because if he is going to going to work there till 24th of August, my lord, till now, my lord, there is no notification or saying that he will be terminated. He is approaching this honorable court just in a apprehension, my lord.
No. No, my lord, I am clearly stated in my paragraph number 14, my lord. Further, the respondent number 5, without issuing any order or official notification restraining the petitioner to perform her duties as an assistant professor under Regulation 3F of Regulation 1951 in Jorhat Institute of Science and Technology, which violates the notification dated 22/4/2025. My lord. That is at page 14, my lord. I am reading paragraph 14, 3, 4, 5. Last paragraph 5. Further, the respondent number 5. This is the principal, my lord.
uh, does it not applicable?
Yes, my lord. The appointment of PF was
It is also an aspect that the post of the petition have not been advertised.
no, not been advertised.
Then those 29
Already released, my lord. They were released.
have been released on account of picking up their by regular
Yes.
Obliged.
My instruction may be kept in record, my lord. And
Obliged,
this
your lord.
is a policy decision, my lord. चलो
May I please, Your Lord? Lordship, in this case, the petitioner, she appeared in her HS exam. Now, when her result was published, in the history, marks of the practical exams were not added to her final mark. And the college authority has also written to the education department for the correction of that mark. But in spite of that, she has been marked absent and she has been declared in the final result compartmental in history. Now I will take your lordship to the annexure E, that is the mark sheet that was published, page 32, Your Lord. Here your lordship will find history is in the first column, page 32, if your lordship has got it, annexure E. Annexure E, page 32.
Yes.
Here your lordship will find history at the bottom. Theory marks is there, practical, she has been shown as absent, ABS, your lordship has got it. And because of which, against the grand total at the extreme right, she has been marked as compartmental in history. Now, I'll need to take your lordship to annexure G at page 34, your lordship. This is a letter written by the respondent number 3, the principal of respondent number 3, that is the college from where she had given her exam, to the controller of examination, respondent number 4 here, whereby they have categorically stated that the petitioner had appeared and had participated in the practical examination. And the principal, had also annexed the documents to prove that. Annexed to page 35, your lordship may kindly peruse. He has been given 18 marks in the practical project history. Page 35, your lordship. And thereafter in page 36, her attendance rate, and page 37 also. So all this was there. And the petitioner has even personally approached the controller of examination by annexure F at page 33 and latest on annexure H, page 38. But in spite of that, though the admission, the new session has already started, your lordship, because of this error in up the mark. Though she had participated, even the college has intimated them. But in spite of that, that marks had not been added, and because of which she has been unable to take admission in the new session here, BA admission, your lordship. So she is before your lordship with regard to this.
My lord, in this matter, my lord, we need to take instruction, my lord, because my lord, this whatever may be the list submitted by the. But did you keep this copy? My lord, that is not.
The marks were uploaded.
My lord, only fix it on Friday, my lord. We obtain instruction, my lord, and my lord may pass the order.
And one seat may be kept.
Yes, that may be.
Because otherwise it has started from the 1st of August. So if it proceeds, at least one seat may be reserved, your lordship, because
In
Kasar College, your lordship, respondent number 3. He is a registered student out there.
Party.
Yes. Respondent number 3, your lordship, Kasar College. And that is the letter of annexure. G is the letter from Kasar College itself.
I love copy date not mentioned, but it is provided by our clerk, my lord. When
We had served them on 11th, I think. We had filed it on
27. Why you not obtain? My lord, on my lord Friday, I obtained the complete instruction, my not on Friday.
Yes, your lord.
Tomorrow, my lord. My lord, the day after tomorrow, then.
Career of a student is at stake, your lord.
Two and four, my some state education for comfort and the controller of the so we have for
1 and 5. Lord. 1 and 5.
1 and 5.
Lord, sir. I had it.
If you
Yes. Yes, yeah. I mean,
the events ought to be addressing that the petitioner appeared in the essence second or in commerce stream the Kasar College and she had participated in the practical paper of the on 1st of February 2025, but she has marked the practical of which in the final result of the part 2 is department. Thereafter, the respondent number 3,
Yes, your lord.
the principal, Kasar College 6
We'll take it today itself.
on the approved by the pensioner by letter dated 555 addressed to the respondent number 4 admitting that the petitioner had participated in her practical and project assignment and had secured 18 marks in the same and requested the response number 4 disciplinary mark. But in spite of receipt of the representation filed by the and of the letter of the principal, the respondent number 4 has not made rectification the mark to the mark. And under such circumstances, the resource current of the petitioner is to direction of the respondent number to take direction with respect to the marks. However, the if the allowed from by object variety of the subject directed to obtain correct on respect of annexer E. Not mark the annexers properly, Mr.
Overwriting.
Annexer F C1 and H. When the press is scored on the effort
Obliged.
The petitioner applied for a seat in MA Peace and Conflict Studies in the Tata Institute of Social Science. It's a deemed university, therefore amenable to read jurisdiction. The Supreme Court has held that deemed universities are within the state under Article 12, therefore they are amenable to read jurisdiction. Lordship, can you see the mail at page 20?
and so that decision of the
Yes, ma'am. Yes. Para 22.
paragraph number 10.
Well, para 22, madam. Para 22. It is in page number 10, madam. Page number 10, para 22. Last paragraph, in fact, madam. This we say, has Malad got it, madam? This we say for reason that first is respondent 1 is engaged in imparting education in higher studies to students at large. Secondly, it's discharging public function by way of imparting education. Thirdly, it's notified of the deemed university by the central government under Section 3 of the UGC Act. Fourthly, being a deemed university, all the provisions of the UGC Act are made applicable to respondent 1, which inter alia provides for effective discharge of public functions, namely education for public benefit of public. Fifthly, once the respondent 1 is declared as a deemed university, whose all functions and activities are governed by the UGC Act, like other universities, there is an authority in the meaning of Article 12 of the Constitution. Lastly, once it has been held to be an authority as provided in Article 12,
then all necessary consequences, it becomes amenable to read jurisdiction of the High Court and Article 226 of the Constitution.
Now, the document
Yes, my lord. My lord, page.
is it can be assumed that Tata Institute of Social Science is the deemed university.
My lord, I made specific statement, my lord. It is there in there, my lord. It is, of course, it is there in their my lord, website. My lord, of course, there is no document as such, but it is there in the website. My lord, it's a deemed university.
Data of their website.
Because my lord, there is no other option to show my lord, that it's a deemed. I cannot have any papers as such, my lord. But my lord, this website shows my lord, it's a deemed university. My lord.
That
I have made a specific statement, my lord.
Institute of Social Science is deemed.
Well, I have made a specific statement in paragraph 2, my lord. This is there in the website itself, my lord, of the Tata Institute of Social Science. In 1964, my lord, it was declared as a deemed university. Because otherwise, my lord, papers will be difficult to find, my lord. That way, my lord, my lord.
Check the website of UGC.
My lord.
Toto,
My lord.
take the data.
Yes, ma'am.
Then in the meantime, we ask the standing topic of the
My lord.
present.
My lord.
Yes, Your Lordship. Paying, basically, I am paying for granting of bail on the length of detention, Your Lordship. Your Lordship, the petitioner was arrested on 25/09/2021. He languished in jail.
This is
For-
first or second or third bail application.
Now, initially, I was granted interim bail. That period expired. Then I was again taken to custody. Then, before the session judge, last order is Annexure 10. It was rejected on 10/5/22. That was immediately after filing of the complaint. Now, in the meantime, about 4 years, Your Lordship, now. And there are many judgments I have. Yeah. Because Gyan Kumar had punished Tina and coordinate benches there.
So whether you have approached this court earlier.
It was, I appeared earlier, then I was granted bail, Your Lordship. Interim bail for a certain period. After that expiry, I surrendered before the trial court. Then I move a bail petition Annexure 10 on, which was rejected on 10/5/22, long bail. Now I am paying for length of detention, Your Lordship. About 4 years. There are many judgments by the Honorable Supreme Court as well as by this Honorable Court and coordinate benches, Your Lordship. Thank you. Now, few days are left for about 4 years detention, Your Lordship.
You have not approached this court earlier.
Long back, I was granted interim bail for a certain period. That period expired. I surrendered before the trial court. Then I move a bail petition before the session judge. That is Annexure 10. It was rejected on 10/5/22. Thereafter, no.
Yes,
Not before.
Respect of file of other bail application. No.
Let the facility and এরকম ভর্তি হয়েছে। Your lordship judgment I have given a bill application number 16 1600 of 25. Your lordship judgment is Rafiqul Haq alias Mirajul Haq. Therein your lordship
Sir, what is your name?
your lordship Prabha Shankar Tiwari.
Your name.
My name is Ranjan R. Majumdar.
So this person has approached several times court, and you have suppressed those success factors.
No, I have given your lordship. Stated. Your lordship, para 5, page 5. The petition states that he was granted interim bail for a period of 20 days. Para 5, page 5.
No, before that also several petitions were filed. But sir, that means
and Gapati Lodge.
That's it. The subject, the BNS the problem for keyword it connects with an like eight upon that first that scan copy of the record also the current trial court method on
17-9.
28. In the meantime, the current court I give the file and additional affidavit linking record all the bail orders passed by the court earlier required by the
Let's note.
These are lordship. Lordship, this case has become infructuous. We have received the pension and other benefits.
art is that
RDAS.
art of art P dot art the learned petition and the has operated the Pensionary bank. It's covered by the public. Okay.
problems.
Deeply utilized. No.
Lordship, I want to refer this matter to legal. Yes, my lord. Heard that? Go. Heard. My lord Seba, my lord Board of Secondary Education. And madam,
And item number, reference number 7, Your Lord. Here.
this matter is under the column. It is submitted the part that considered by the part and there is done for set up the part that taking up better part let's set up the idea of it and the part direct of subset of the part of four. That's number 7.
Yeah. Item number 4.
They're referring to the method. Yes.
Right.
Please move. Referred.
In this matter, some instruction we need. Some instruction we need. We need some time to take the instruction. first.
That's right, but the matter, madam, the matter is listed under the column for referral to the special petition drive.
What?
Petition for the. Is there any such setup?
Lord.
Refer.
We are ready, Aman.
It is instruction we can add.
Malad, they can apply instruction during the mediation process also, Malad. During mediation process, instruction can be taken by the other side. If he is to yet to get instruction, and this is the matter of 2022, Malad.
Yes, sir.
Lordship, after 2 weeks, we need to take instruction. Is this? Lord.
Or, sir.
Yes, sir.
Or
B-Tech.
B-Tech.
Lord.
Elementary
Elementary education.
take the subset. Take away. Right, programming her on time of and thereafter refer their one or
2 weeks, Lord.
But can it be a specific date may be given? Malad.
May it be pleases you, Lordship. Here, Your Lordship, Deputy Director of Secondary Education has wrote the letter, Your Lordship, to Inspector of School, instructing him, Your Lordship, as earlier petitioner advocate counsel submitted that there is the only calculation part that is calculating 110 days, and she submitted that number of actual days of leave encashment should be 175 days, and the period of such calculation is with effects from 5/6/1995 to 31/12/2012. So in this pertaining context, Your Lordship, they are requested to submit a proposal to the director for sanction of the residual leave encashment benefits at the earliest, along with necessary supporting documents. For that, Your Lordship, petitioner was asked to visit the office, Your Lordship, along with the necessary documents. Like,
Lordship, the
Place
matter here relating to pension, Lordship, the pension proposal, Lordship, with regard to that audit clearance certificate and service book, there is some correction. The respondents were asked to bring the instruction. And Lordship, there has been a calculation mistake on the part of leave encashment also. That may be rectified. And if necessary, the petitioner will approach the office. Lordship may fix a date. In the meantime, they will rectify if
Yes, Your
necessary,
Lordship.
and thereafter the matter may be.
If he is found to be eligible for additional leave encashment, Your Lordship, for that, Your Lordship, petitioner is requested to visit the office along with necessary documents. Kindly 3 weeks time may be granted.
Which office he has?
Director of Pension.
Deputy Director of Secondary Education, sir. And this is matter relating to pertaining to pensionary benefits.
Pension department.
নালাগে আমার এটা বলে হল secondary education.
No, this letter is addressed to the inspector.
Deputy Director, yes, Your Lordship, addressing to the
He is
Inspector of School.
reexamine the matter.
Yes, Your Lordship. Inspector of School.
With the office of
Inspector of School, Amingaon. Rural day too.
Third is
8 Alukdar.
a Talukdar. The and verify that and if the that order of the proposal or directorate even when the artist does order something first verify the record of the yes, of like having along with the document and press for this method after
3 weeks.
or
Instruction may kept as on record zero.
eight of the and here that that's the complaint of the for on
50.
instruction director A
না
Wait.
হবই
and
কোন
the female part.
I'm deeply obliged.
Obliged, Lordship.
In this case, my lord, Retipil is pending, my lord. Retipil is pending. And Retipil is going to held on in the month of September, my lord. Yes, I have mentioned, my lord. So Lordship will kindly fix this matter. Page 23, para 28. There is no date, of course. Retipil will be heard in the month of September. Last occasion.
That will lead the matter after vacation.
Yes, my lord.
Or it will be and it be data. Maybe the next statement for that.
Yes.
That one thing. Retable number.
Retipil number 171/2023.
And the thing is that for in the month of September and as a matter after the vacation, according to that, 187 of after the vacation.
8, 9, and 11.
11 also, Lord.
11 also. 11. Oblige, your lord. Right, yeah.
There in the website also, my learned friend is.
Lordship, I'm appearing on behalf of Mr. H. Umar. Lordship, as per his instruction, the institute is divine. Lordship.
Well, it's there in the university, government of India website also. It's there. I've given that. This. Well, here what had happened, Miller? There was an advertisement, Miller.
Madam, you can go.
Right.
Miller, let me kindly turn to page 21, Miller. Well, initially, he do applied for Miller MA in Miller social work. Miller under the end Miller 21, Miller. Miller, there was a Miller spot admission Miller notice Miller, or rather a mail Miller. 6th of August 2025, Miller, page 21. Lordship will see Miller. Admission team Miller. Date 6th of August 2025. Dear candidate, please find below the link to check available seats for details, spot admissions, and Zoom links details. So it was through a Zoom Miller interview that was to take place on 7th Miller. This Miller mail was sent. And page 22 Miller is the seats available Miller. Miller, the petitioner applied for Miller peace in conflict studies Miller MA course Miller. That will be serial number Miller 5 Miller. Miller Guwahati campus Lordship has seen Miller.
Serial number 5.
Serial number 2 under Guwahati campus. That Miller column number Miller 5 Miller.
Page number?
Page number 22 Miller. Lordship has got Guwahati campus Miller.
Column number?
Miller, second row Miller thereafter, row Miller thereafter. Master of Arts in Peace and Conflict Studies Miller.
Master of Arts in
Peace and Conflict Studies.
Okay.
Lordship will see seats available.
There is no serial number.
Serial number is not there, Miller. Serial number there. Miller column number 1, 2, 3.
Available 2.
2, Miller. And for Northeast Reservation, 14. Miller, I'm not concerned with that because it was for All India seat, Miller. He's from Odisha, Miller. He applied, Miller. Now, Miller, 2 seats were there, Miller. Now he accordingly applied, Miller, and Miller, as per Miller, since he was Miller, it was a spot admission, Miller. and his name starts with S, my lord. He's Sudipta Das, my lord. And my lord, he was there all along, my lord, in the my lord, site, my lord, and only 2 candidates appeared. We made a specific statement, my lord. Now, my lord, thereafter says the results were not declared, my lord, some mails were sent. Now, lordship will find, my lord, at page 26. My lord, that's a mail of 11th of August 2025, my lord. Dear candidate, reservation rules are applicable for spot towns also. There are no general seats available. So, my lord, here in the advertisement, there was no mention of, my lord, any reservation with regard to these 2 posts, my lord. These are apparently, my lord, open posts. Because, my lord, Northeast reservation, my lord, is, my lord, shown, my lord, specifically 14 vacancies. I'm not concerned with that. I'm only concerned with the All India vacancy, my lord, where there is no, my lord, reservation shown, my lord. And it is because of this, my lord, there being no reservation shown, my lord. Otherwise, I would have chosen perhaps some other course also, my lord. I choose this course, my lord. Now, my lord, they say, my lord, is that over telephone they said, my lord, that if you don't get in mail, my lord, you are not selected. So therefore, I have presumed, my lord, that I have not been selected, my lord. And my lord, now of course there's another advertisement, my lord. Page 28. This is now for non-CUVT, my lord, category, my lord. So they hold these tests under different categories, under CUT category first, my lord, then spot admission category, my lord. They, my lord, and then, my lord, now non-CUT route, my lord, has been, my lord, page 28, my lord, and, my lord, there is a, my lord, process going on, my lord. The entrance test will be held on 23rd of August 2025, my lord. Page 28, my lord. Entrance tests are going to be held on 23rd of August 2025, my lord. Lordship got it, my lord. And the results will be declared on 20, my lord, 6, my lord. But here, lordship will see, my lord, in the Guwahati campus, my lord. Again, my lord, advertisement has been made. Of course, again, here, there is no general seat, my lord. But just for the, my lord, lordship's, my lord, the information, my lord, I'm placing it before lordship, my lord. Now, lordship will find here, my lord, page 31. This may be relevant because when under, my lord, Northeast vacancy, my lord, 17 seats are shown, but no, my lord, reserve category seats, my lord, are shown again to be vacant also. Now, my lord, my information is, my lord, that only 1 candidate has been selected, though I was the 2nd candidate, my lord. They say now that, my lord, they don't clearly say, but then they say no reserve seats, my lord, vacant seats are, my lord, unreserved seats are available, my lord.
Now, what is your prayer?
My prayer is, my lord, at least 1 seat may be kept vacant at this stage, because, my lord, otherwise, my lord,
so it's in such direction, we have to ascertain that one time.
That is also there, my lord. I understand that, my lord. So, my lord, now they don't have any standing counsel. Otherwise, my lord, things would have been different, my lord. I truly understand your lordship, my lord, what is lordship falling from your lordship, my lord. My lord, the difficulty is, my lord, that, my lord, I have made a specific statement, my lord, that only 1 candidate, my lord, there are 2 candidates only, my lord. I was one of them. And, my lord, without being specific, my lord, how they filled this post up, my lord. By their mail, they have said, my lord, that's this, my lord, posts are, my lord. There are no reserved vacancies, my lord. Sorry, my lord, there are no unreserved posts. Which, my lord, was not there in the advertisement, my lord. Now, the advertisement has to be very specific, my lord, that whether there are vacancies, reservations or not, my lord. Because, my lord, it being a deemed university, my lord, the Central Educational Institution Reservation of Admission Act is applicable, my lord, where the vacancies, my lord, are to be, my lord, reserved, my lord, as per the, my lord, their, my lord, the reservation, my lord, process is, my lord, there, my lord, and they have to, my lord, keep seats vacant, my lord. So, my lord, there is nothing, my lord, in the advertisement which indicates, my lord, that there were any vacancies, my lord, for reserve category, my lord. And the advertisement, it appears, my lord, these are all, my lord, general category seats, my lord. Now, my lord, as per, my lord, this reservation, my lord, act, my lord, 15%, my lord, is to be for scheduled caste, my lord. Then, my lord, 7.5% for the scheduled tribes, my lord, and, my lord, 27% for other backward classes, my lord. That, my lord, even backward classes, there are, my lord, candidates, my lord, then, my lord, general category candidates also can be given, my lord. that those provisions are there. But as your lordship has put this query, my lord, how, whether there are vacancies or not, my lord, that is of course, my lord, so my lord, and can I, my lord, this my lord, let the status quo order be issued then? And lordship will issue a short notice, if necessary, my lord, take dusty service, and my lord, the lordship will fix it next week, or my lord, next Monday itself. Dusty service is the only option because they don't have any standing counsel if this is to be resolved early. Otherwise, also an admission matter, my lord, it cannot be my lord, prolonged that way also, my lord. So it has to be sorted out, my lord. Either
Friday or
my lord.
yeah,
My lord, I'll make an attend, my lord, because the Guwahati campus, so my lord.
or for admission with the first studies for the Guwahati campus. And at the time of issuance of the advertisement, the posts were reservation, the posts were indicated in the advertisement, and thereafter candidates, including the petitioner, appeared in the interview, and it was expected, but as far as information received by, he has not acted for the aforementioned.
By mail dated 11th August, my lord, I was informed that there are no general reserve seats, page 26.
And thereafter, 11th of August, 5, the prisoner was informed by mail that the post
There are no general seats available.
were
My lord, page 26, my lord, about my lord, 6-7 lines, my lord. Dear candidate, reservation rules are applicable for spot rounds also. There are no general seats available.
and on 11th of August, 5, by mail, which was on that whether the rules are applicable for spot round also, and there is available, no general seats available. But as for information, for his information, the petitioner was the only candidate. Option by the one candidate was third vacancy still exists, but the authorities have made that the posts are available, is available. So there are specifically in that third active approach support that notice by registered city work justice of the market and after effective service justice council by the matter on Friday.
Well,
Interfere
but there will be my lord, seats instead of posts, my lord, because it's perhaps the seats maybe, instead of post, my lord, it may be seats, my lord, because these are all. Deeply obliged, your lordship.
Get rid of it. Okay. That's great. And
Deeply obliged. More mother. Deb.
one more. That's it.
Lordship, pleadings are completed in these matters. Lordship, our pleadings are completed in these matters. It may be picked up for hearing. But your lordship,
There is admission.
yes. Pleadings are completed, your.
That's all right. There is accordingly it is listed for admission today.
Yes.
It pleases my lord. My lord, with respect to item number 16, yesterday we have filed on our affidavit in opposition, my lord. Perhaps it's not in record, my lord. On behalf of Financial Taxation Department. Yesterday we have filed it. But you could have the matter in the morning. My lord. May I pray for listing this matter after 2 weeks, my lord? Why? For the 18th matter? Yes, my lord. Next week then? Next week. The secretary by Lord. On the meantime, affidavit filed by the members. Oh, one was it? Text ने तुम्हारा text 2 1 2 respondent number 1 and 2 my lord. Text 16.
Okay, I have seen it forward.
Bless me.
Respondent number 7.
Your name?
K. Borpuchari.
K?
K. Borpuchari.
Yeah.
On behalf of Chairman, my lord.
I'm calling for I also city and for number 1 and 5. What is your submission?
Lord, this is in view of their affidavit, the subsequent affidavit, whereby they have brought the, well, the OM that is in 2019 issued by the government of Assam. In view of that OM, they have issued one annual notification by which the direction was given to us to obtain the NOC from the government, then will they go for the affiliation. So we have challenged that notification as well as the OM, my lord. Because in earlier case, in the first affidavit, they did not brought these things, my lord. In subsequent,
So like the council is
yes, my lord. So, my lord, if there is any counter, they have to file. Then they can file, and otherwise, my lord, that will be notice may be issued on this side.
not filed yet.
The notice may be issued on IA, my lord.
Lordship, we have the office memorandum. The senior will bring that today.
No, this
So
is
I
on
don't know
IA, my
what
lord.
timing.
Notice may be issued, my lord.
So hard. Hard. By the applicant. What is your pair in this introductory application?
My lord, for setting aside this, my lord, both the OM and the notification. In respect of my case, my lord.
Select the memorandum number A.84 of
27 or 28.
26th of February
Seven,
higher part number by the registered body in respect of the
all are API, my lord, so no formal notice is required. I will serve the copy, my lord.
by the
I'll serve copy to all the people.
forward extradition the method.
My lord, on 27th of this month, my lord, is possible, my lord.
One. Only 5.
And on 27, my lord. 27 of this month, my lord.
Part of
You want to say?
part of the
September. Most of this.
Deeply obliged.
Well, that may be given a pardon, my lord, because lordship were earlier given a pardon, my lord. This is because already so hard in length, my lord. This is
Procedural. If this matter pertains to medical reimbursement, what happened, Lordship? Husband of the petitioner was an employee of Board of Secondary Education, Sabha, Lordship. And
he
Lordship,
was employee of Seva.
Sabha. Lordship, he underwent a coronary artery bypass grafting surgery, Lordship, CABG surgery, on 29 July 2018, Lordship, in the Health City Hospital. Without obtaining prior permission from the Sabha authority, Lordship. So his son subsequently on 1st of August, 2 days thereafter, his son represented before the Sabha authority, praying for according permission in the treatment. Lordship, that representation was rejected by the Sabha court. And subsequently, during the lifetime of the husband of the petitioner, Lordship, he represented before the Sabha authority, claiming for reimbursement by granting ex post facto approval. And that prayer was also rejected, Lordship. That prayer was kept pending, Lordship, was pending. And subsequently, the husband of the petitioner died due to COVID-19, Lordship, in the year 2020, Lordship. And subsequently, the representation filed by the husband of the petitioner was unanswered by the Sabha authority. And on being aggrieved, Lordship, the petitioner has approached before this Honorable Court by way of filing a writ petition, first round of litigation, Lordship. And this Honorable Court, after hearing both the parties, Lordship, this Honorable Court has held that there is no requirement of obtaining prior permission to save one's life, Lordship, because preservation of life is the concomitant, Lordship. It emanates from Article 21 of the Constitution, Lordship. That order, Lordship, will find operative per Lordship, page 154, the writ petition, Lordship. Petition number 1481, Lordship, Annexure 15. It starts from page number 133, operative portion, Lordship, page 154.
What was the direction here?
In para 25, Lordship, this honorable court has held that under such circumstances, as your Lordship got it, page 154.
Yeah.
Under such circumstances, since there is no denial by the board in respect of the medical treatment undergone by the petitioner's late husband, it is directed that the board will re-examine the matter and after due verification of the claims made by the petitioner for medical reimbursement of expenses incurred for medical treatment of the petitioner's late husband, the board will grant ex post facto approval if required and thereafter reimburse the medical expenses incurred in respect of the treatment, including surgery undergone by the late husband of the petitioner. The respondent board may take recourse to clause 17, which provides for relaxation, if so required. The entire exercise will be completed in the transfer period. Subsequently, Lordship, petitioner submitted the original bills before the SEBA authority, which amount 7 lakhs. That's what SEBA authority did, Lordship. They have sanctioned an amount of rupees 3 lakhs. That is annexure, Lordship, 18. Annexure 18. Page 160, Lordship. As per the prevailing rules of the SEBA, Lordship, SEBA health regulation, the husband of the petitioner was entitled to full reimbursement.
As per
SEBA health regulation, 2016. Kindly have a look,
it is
Lordship.
part of the record.
Part of the record, Lordship.
Page number.
Page 61, Lordship. Page 61, kindly have a look, Lordship. Regulation is annexure at annexure 11, Lordship. Page 50, start from page 50. But relevant rule is, Lordship, page 61.
Yes.
It is provided, Lordship, full reimbursement. Rule 13, Lordship. It's rule 13.
Yes.
Full reimbursement of expenses of the following type of treatment may be allowed, subject to submission of certificate from authorized medical attendant in the referred hospital concerned, whether medical treatment, stroke surgical service is actually availed by the parties. Type of treatment, number 6, Lordship, bypass surgery. The husband of the petitioner availed this surgery, Lordship. So, full reimbursement he is entitled, Lordship. This honorable court also directed to that extent, but SEBA authority set a warrant appeal, Lordship, upon the order passed by your Lordship, by sanctioning only an amount of rupees 3 lakhs. This is my case, Lordship.
What is the total amount?
Total amount, Lordship. Page number 159, Lordship. Page number 159. Original bills were submitted.
That is the application.
Application, Lordship.
What is the document that you are
Lordship, all the bills have been annexed, Lordship. Annexure 6, Lordship. Annexure 6, page 37.
What is the page number 176? Where it is the maximum reimbursement. Then it is the respect of action. Yes, my lord.
This is the amended regulation, Lordship. That is come into force, Lordship, from 1/1/2019. 19.
Your claim.
2018, Lordship. No retrospective effect can be given, Lordship.
This regulation came force effect from 1st of January 2009.
And the amended regulation,
Yes, ma'am.
by which only sanction of rupees 3 lakhs is given, Lordship.
On the basis of
And any treatment, Lordship. But earlier it was full reimbursement, Lordship. Subsequently, they have amended
which were covered by the
earlier regulation.
Now that if I that this 7 lakh the treatment
Bill, Lordship, starts from Annexure 6, Lordship, page 37.
where is the total calculation?
Lordship, page number 157, the SEBA authority has acknowledged, Lordship, the bills. Calculating, Lordship. Page number 157, Lordship. This is the acknowledgement of the SEBA authority. Sorry, Lordship, page number 159. 159.
That is your application.
After due scrutiny, Lordship, by the receiving staff. Because the amount were mentioned, Lordship, in the representation itself.
Yes, Sir Roy. My lord, kindly come to page 166, Annexure A of our PDPT operation. This is a board meeting held on 7 December 2022, my lord. 166. Yeah. This is a board meeting held on 7th of December 2022. And my lord, kindly come to the page 170, my lord. Agenda item number 10. May I read, my lord? My lord, they are to discuss the matter of reimbursement of medical bill submitted by Surya Begum, wife of late Nazirul Islam, ex-assistant controller SEBA, regarding the case WPC 1481 of 2022. Surya Begum, wife of late Nazirul Islam, ex-assistant controller of SEBA, has requested for reimbursement of medical bill in regard to the treatment of late Nazirul Islam, ex-assistant controller of examination SEBA. Total bill amount is 7,04,068 only. Treatment was availed in the Health City Hospital, Guwahati. Honorable members of the board discussed the matter and decided to release the amount as per Medical Attendance Rule 2016, amended in 2019, which is rupees 3 lakhs in case of the retired employee. And kindly come to the amendment regulation, my lord, at page 174. Annexure B. This regulation come into force with effect from 1/1/2019. Come into force from 1/1/2019. And here, my lord, at page 176, clause number 9C, the maximum reimbursement of medical expenditures subject to 3 lakhs. My lord, that has been released the amount of 3 lakhs as per both norm, my lord. And my lord,
The petitioner be covered by which earlier
no, my lord, this amendment rule, my lord.
how?
My lord, kindly see here.
Treatment period.
Yes, my lord, kindly see page 48 of the writ petition annexure 10. This is a representation submitted by the page 48, my lord. Prayer for according ex post facto approval for reimbursement of medical bills of Muhammad Nazirul Islam, my lord. Submitted on 27/6/2019 only, my lord.
That is not material in my humble submission, Lords. The operation was conducted in the year 2018.
It is different,
2018.
2018, 29 July 2008.
Where the date is mentioned?
The discharge. Kindly have a look at Annexure 5, Lordship.
Annexure?
Annexure 5 is a discharge slip also. And another, this is, and another is Lordship Annexure 4. Kindly, at first, Lordship Annexure 4, Lordship. This is the first discharge certificate. Because the husband of the petitioner was subsequently admitted due to secondary infection. The first discharge, Lordship, is Annexure 4, is 26. Date of operation 29/7. Is clearly mentioned.
Annexure 4.
Annexure 4, Lordship, page 26.
Date of operation was 29/7/2018. And when you have filed the reimbursement petition?
27/6/2019, my lord.
While the husband of the petitioner was in a bedridden condition in the hospital, the son represented before the Sabha authority on 1st of August 2018. August 2018. Lordship, page 45. Type copy, Lordship. Vernacular, handwritten, Lordship, page 46.
Yes, sir, or any doubt about this Annexure 8?
Annexure 8, my lord, my lord, this only for according permission, my lord. Because that hospital is not empanel hospital to the board, my lord. And even thereafter, my lord, on the as per direction of this honorable court, my lord, at page 154, paragraph 25, my lord, the honorable court has directed the board to re-examine the matter, and after due verification of the claims made by the petitioner for medical reimbursement of expenses incurred for medical treatment of the petitioner's late husband, board will grant ex facto approval if required, and thereafter reimburse the medical expenses incurred in respect of the treatment, including surgery undergone by the late husband of the petitioner. Thereafter, my lord, board has decided in the meeting, my lord, and as per norms, my lord, as per amended rule 2019, my lord, is entitled to receive 3 lakhs, my lord.
Operation was conducted on
29/7/18.
Then which rule will cover the case of the
My lord, earlier, my lord, this 2016, my lord, at the time of treatment, my lord, when he was getting treatment.
then under which provision you both have considered it?
But the releasing of, my lord, reimbursement of the bill, my lord, that will cover, my lord, 2019, which is coming to force on from 1/1/2019, and
But the operation was conducted the period of earlier.
yes, my
Then
lord, earlier, my lord, as per both norms, my lord,
what is the norms of the board then?
my lord, at that period, my lord, 2016, my lord, which that hospital was not empaneled hospital.
Maybe
Yes, my
there are several decisions of different courts.
yes, my lord.
The event of non-empaneled hospital also
Yes, my lord. And my lord, and already the wife of the petitioner, my lord, already accepted, my lord, that the sanction amount of 3 lakhs at page 161, my lord.
that she may accept, but it does not mean that she has abandoned her claim for rest of the amount.
Yes, my
There was a necessity and therefore she has accepted the taken. But it does not mean that she has abandoned her claim for rest of the amount. Is it?
No, my lord. These two, my lord, but board runs by the fund collected by the student fees, and my lord, board has to think about the, my lord, expenditures also, my lord.
What does it even something that the payment was made from the fund collected from the student?
Yes, my lord. I know the board is an autonomous body, my lord, and it runs.
Yes. Do you have received any grant from the government?
Yes, my lord.
Is it?
Yes, my lord. And my lord, as per my lord, this 2019 regulation, my lord, amended, board has released the amount of 3 lakhs, my lord. After verifying, my lord, claims of the petitioner and re-examining the matter.
Yes, madam. Is it the correct statement that the board has not received any grant from the government? Can you obtain instruction?
Autonomous body.
Pardon?
Whether grant, they have received grant or not.
Yes, from the government. We'll take it away at 2 o'clock.
Yes, ma'am.
Say.
Yes, ma'am.
Madam, please inform.
Instruction from Lordship, from the government, means
Government.
from whom? Finance department or
Yes, fine.
then Lordship, the standing township finance, they will.
But since you were representing the government, you obtain instruction from the finance department. Inform this court at 2 o'clock.
Yes.
Much okay.
Wait, please.
Madam, the IA
Yes, ma'am.
we have also has not yet been fixed. After some time,
Master.
next.
Item my lord 22, I filed one IA my lord for impeding as a party respondent number 8 my lord. IA 2027 my lord.
Item number?
Item number 22.
Lordship, the standing counsel F. Ukon is on legs at court number 7. So,
Standing counsel?
yes, Lordship.
Or?
F. Ukon, Lordship. 22 and 23.
Education.
Okay, after some time.
Yes. Obliged.
Lordship, may peruse the last, the order dated 8/4/24. What did?
That's the PECO, the
kind-
information.
Lordship, because Mr. Pegu was not there that time. But in one of the date, I'm sorry, I'm not able to say, but they had bought a thing showing regularization, but there is not a part in the part of the record. It's not put in the record book, and neither it was recorded in the order.
They have produced one.
Yes, yes, documents.
Regularization.
Yes, yes.
Clear.
If I'm not mistaken, yes, yes.
Kindly grant 1 week time. I'll take updated instruction. No,
Why
both-
1 week? What is the order? Then the
that instruction I don't find.
Then let him say what about this order, what they have followed it up. No, not. They'll bring the instruction.
Okay. But as per me, current like part PECO comes at the time obtain the instruction as required by order of court within 8 where the secretary allows the method on
Yes.
Publish. My lord, this IA is for correction of the cause list. Name was wrongly written as Sunita Patwari instead of Sumita Patwari in the writ petition, my lord. Lordship comes to page 8 of the IA. Lordship has got it, my lord.
Yeah.
Page number 8. It was written as Sunita Patwari. The name ought to have been Sumita M. The affidavit was signed as Sumita. Sumita. The Wakalatnama was signed as Sumita. In fact, my lord, everything except the cause title, it's a typographical error on the part of the council, my lord. Name M has been replaced as N. Yes. Only that much correction is required. I.
only in the cost title.
Only in the cause title. Everywhere, including the lordship, if at the file of the writ petition, lordship may see the Wakalatnama, the affidavit, everything.
Okay. Any objection?
No, your lordship.
Or sir?
T. Chakravarti.
ইয়াতে থব
T. Chakravarti T. does or the for correct our name in the section order of this dated 14/5. But if title also application, there also it is mentioned the first.
Yes, my lord. Post title was wrongly typed as in the writ petition. Lordship will kindly.
No, in your application also.
Yes. No, because writ petition,
Sumita Patwari, it was written, your lordship, in the writ petition also.
what I am saying, my lord, that whenever.
So page number 1.
Yes, my lord, the interim, whatever is written in the original writ petition, that was required to be written in my understanding, my lord. If it was written wrongly, since it is the outcome of that writ petition, In that petition, it was wrongly typed. Subsequently, Lordship, we say the second
It
page.
will be written as allies, your lordship, as per my knowledge,
Page
your
3,
lordship.
Lordship, kindly come. Page 3. The right name has been written, my lord. Page 3. Lordship, we got it, page 3, my lord.
তার নাম তো কি হয়? সুনিতা।
Sunita.
কিন্তু ইয়াতে তুমি এলাইজ দিব পাৰিলা।
Typographic failure.
correct name of the
এলিয়াস দিয়া হয়, এইটো it can be stated.
person name that's there is that correct the therefore that person the order
Was that the repetition?
person by adding that transport the word the debate that conflict to the order of the number that the all purpose.
And deeply obliged.
Deeply obliged. May it be pleases you, lordship. Today we have received this bunch of original records, your lordship. To go through it, your lordship, kindly matter may post it on Tuesday. This Tuesday.
In this case,
We have taken
in fact,
consent.
my case is tagged with this. Earlier, it was, I don't know, 24. That was had it similar matter. It is, if lordship permit, in very short, I can place my case. So that lordship can think the parameter of the case is not a bigger magnitude. Question is, I was appointed after a due selection. After due selection, I was appointed. After appointment, I joined. My salary has not been given.
D. Kaushik will be appearing in this matter.
Go to the record.
Your lordship, it was a bunch.
My lord-
Today morning itself, we received it.
My lord, my lordship was pleased to hear the matter, my lord, and as a partner, my lord, the record was called for. My lord, the only issue is that, my lord, the cabinet memorandum by which the entire benefit has also been extended to us. Now, my lord, when the order of regularization and appointment was issued, my lord, we have been excluded. That is our case.
That's all right.
My lord.
Yes, right for granting her
My lord,
right
my
to
lord.
go to the
A
record.
short date may kindly be.
26th on Tuesday.
Tuesday.
Already out of cases take conference.
Then 28th hearing day. First of September, it will be Monday, your lordship, not hearing day. Second,
Thursday.
Thursday. 28.
Thursday.
I'm deeply obliged.
Here,
Mal. Lord, in WPC 935 of 2023.
you are in 9:30.
Item number 25.
24.
24.
Okay, that's the 4 by
Oh, yeah, 24.
110.
26.
My is 411.
Okay.
023.
Next topic. department submitted the file today.
Today, original records.
Price for sign say yes,
Mal, highly obliged.
as ordered.
Mal.
Deeply obliged.
May it pleases my lord. My lord, before my learned senior starts from the other side, I have a small prayer, my lord. My lord, arguing counsel Mr. B. Chaudhary is arguing a part-heard matter in another court, my lord. This should take some time, my lord. May I pray for fixing a short date, my lord.
Lord, after a very long time, my lord, I could able to matter is on board today, my lord. So as there is a difficulty, my lord, so no, short date, my lord, as per the convenience, my lord. 20.
Can I fix it up month of September?
My lord, a person has been suspended, neither reinstated, is now without salary, my lord. They are saying that I am a contractual employee, so I am not entitled to subsistence allowance, nor entitled to suspension. I have been restrained from attending my duties. That is my position, my lord.
In fact, you are not a contractual employee.
No, I am a contractual employee, my lord, but their rule says that the normal discipline and appeal rule will follow and govern me, my lord, for punishing me. Now they are taking a different view, my lord, in their affidavit. That for contractual employee, there is no procedure is required to sack from service, my lord. That is their stand. If my subsistence is given, my lord, at least I can survive, my lord. 2 kids, school going children is also there.
Praying for a short date, my lord. H. Burma, my lord.
28 of
BTC.
SSA, my lord.
SS. Six.
highly obliged. Highly obliged.
Highly obliged, my lord.
Also, here also a similar prayer because these matters are being handled by Mr. B. Kaushik. So Lordship, I don't know, regularization of service for us. So Mr. B. Kaushik is dealing with these matters. So Lordship fix along with that there is another item was fixed.
No,
on
no, it
20.
is not connected, my lord. It
No,
is a
otherwise also. On 28, Lordship.
Yeah.
Lordship.
Lord, affidavit has not yet been filed, my lord. I have not received any affidavit till date. Affidavit is required, my
lord.
Lord, my lord, after 3 weeks, matter can be posted, my lord.
Heard here, yeah, heard it. Heard that. Heard it. Fine. That right, that affidavit that required. According that file. That it on or
After 3.
Mal, Lord, obliged, my lord.
My lord, learned friend on the other side is not here, my lord. Matter is urgent, my lord. Matter will be adjourned for the time being.
time being.
The time being. Most of it.
In this case, the lordship. Lastly, we have filed an affidavit on 20th March. The main gist of the case is that as per Annexure 7 of the writ petition, as per order dated 28/2005, our services were regularized by the government, although earlier appointed as on irregular basis. After regularization, we are not paid any single amount. So in this case, the respondent number 3 and 4 have filed their affidavit. denying and stating us as irregular plus illegal. Although no document has been annexed, but an WT message was annexed where our as per the WT message, our salaries were stopped. Now, recently we have come to the knowledge that from the same list, some of the person's service has been regularized. That is, based on our information, we have filed on 23/2025. So we have annexed one appointment letter also. He was from serial number 9, and an order of his regularization and appointment was also annexed. That's annexed on page 128. So there is no instruction has been received or reply that extent by the respondent. But after filing of this affidavit, this is the day this matter has been listed, Your Lord. We have filed it on 23/2025.
It's for 128.
Yes, Your Lord. It is that same list. Is
Pardon?
is from the list of similarly situated teachers where service has been regularized as per order dated 28/2020. Sorry, 2005, Your Lord. Some others we have also mentioned, but
Now you tell me whether the matter is ready for hearing.
otherwise ready for hearing, but lastly we have filed it. Otherwise ready for hearing.
Yeah.
Lordship, standing counsel Mr. F is still on legs at court number 7, Lordship. May be taken after some time.
In that case, Your Lordship, I fix the date because I have some other matters for hearing that.
Third, third, and third,
F1,
your name.
K. Rasmedi, Lordship. On behalf of
In
F.
order. The price of the- after a week,
After 5th of September, Your Lord.
there-
Much obliged.
Obliged.
Milord, extremely sorry, Milord, regarding item 17, Milord. Milord, has been adjourned for 1 week, Milord. Can it be taken up day after tomorrow, Milord? There is an urgency. They are availing stay order for last 4 years, Milord. I am for the Guwahati University, Milord. Since, Milord, they are not interested, Milord. They are not interested, but they are availing status quo order since, Milord, 2021, and university is suffering. So on the last occasion, I have pointed out the aspect, Milord. So it was supposed to dispose of today itself, but since they are absent, Milord, so matter may come up day after tomorrow, Milord. Urgent, Milord. Day after tomorrow. No problem.
Please go.
Madam, I not wait for some time.
Must.
Lord, item 22, I'm ready, Milord. Ending at 2 o'clock, Milord.
20.
Yes.
Both the parties are
Yes.
ready.
All are ready. In the
Lordship, standing counsel is on legs at court number 7. So in a part hard matter, Lordship.
after 2, Milord, he is available, Milord. Certain instruction, Milord, with urgent.
Obliged, Lordship.
I'm being at 2.
May please, Your Lord. My other side made a mention for upgrading this matter, but he just called me that he got stuck in some traffic jam. He is coming, my lord. My learned brother. So I can start also, my lord. He has said that he'll join. My fine. Much.
Yes, Lordship. In this case, Lordship, actually, instruction, Lordship, received from the Secretary Education Department, Lordship. The State of Assam has not done any financial assistance, Lordship. It is a self-finance, Lordship, and autonomous.
Self-funded,
body.
my lord.
Self-funded.
And my lord, we have stated in our affidavit in opposition, paragraph 4, my lord.
And as per their regulation, Lordship, it is
Schools are framed by themselves, Lordship. Now they are taking contradictory stand.
Okay. Lord, page 4, my lord, functions of the board and duties of the officers of the board. 3, my lord, and 3.1, finance and budget committee. Clause 4, my lord, at least 5 months. Subject to the approval of the board, functions of the committee shall be A, to recommend appropriate regulation and or amendment of its existing regulation for management of the board's fund, to manage and regulate the finance, accounts, and investment of the board. C, to invest subject to provisions of the act any money or parts thereof not required for immediate.
Sir Roy,
Yes, my lord.
is there any statement or averment in your affidavit of opposition that there is shortage of funds?
My lord, here. Yes, my lord, here, my lord, at paragraph 4 in our affidavit in opposition, my lord. Kindly see, my lord. May I read, my lord? That the deponent begs to state that page number 164.
Yes.
That the deponent begs to state that on receipt of the order dated 22/6/2022 passed in WBC number 1481 of 2022, the board has discussed the matter for reimbursement of medical bill submitted by Surya Begum, wife of late Nazirul Islam, ex-assistant controller Seba, in agenda item number 10 of board's meeting held on 7/12/2022. After discussion amongst the members of the board in the aforesaid meeting, it has been decided to release the maximum amount of rupees 3 lakhs as per Medical Attendance Rule 2016, amended in 2019, which is applicable in case of retired employee of SEBA, like the husband of the petitioner. It is pertinent to mention herein that the board is an autonomous organization and it is run on the revenue collected from the students' fees only, and there is no financial assistance from the government. Hence, it is not feasible for the board to overbear any amount in any case. The claim of the petitioner is rupees 7 lakhs, which is not covered under the rule of the board. However, as per direction of this honorable court in WBC number 1481 of 22, rupees 3 lakhs has already been released to the petitioner and the same has been received by the petitioner.
So, is there any indication in this paragraph that there is shortage of funds?
Shortage of fund, my lord, we have not stated in the affidavit, my lord, but we board in case of the petitioner, my lord, it's not feasible for the board, my lord, to overbear any amount, my lord.
Does it mean that you pay the right of change and overbear the same?
That is not, my lord.
With the pass the order.
Yes, my lord.
May it please your lordship.
I saw, but
There is some, in true sense, there are some clerical errors, typing error, your lordship.
Yeah.
In my additional affidavit, fresh additional affidavit, your lordship, that I have filed at page 165. 165 to 176, your lordship, in two pages. There's some typographical mistake, your lordship, which I have stated in my IA at page 3. At para 3, your lordship. Those printing mistakes at para, page 6, para 3, your lordship.
and paragraph for page number 7.
Page, in my IA, page 6, your lordship.
7.
Page 6, paragraph 3.
Paragraph number 4.
3, your lordship.
4.
For that I have corrected. The specific correction, your lordship.
4 is corrected.
Yes, your lordship, corrected. The case number I have written. May I be pleased to read over para 3?
Yes. Copy not furnished.
Additional affidavit probably not furnished to us, but IA for affidavit in opposition has been served to us. Here it is in the matter of an affidavit in opposition for on behalf of writ petitioner to the interlocutory application under Order 1, Rule 3 of Code of Civil Procedure, reduce 151 of the CPC upon IA 1.
I was served. I was, because it is the separate, it is not already served. That is another, it is an impleading petition, your lordship. That is totally different. You have no. Yesterday it was 5.
You please. I.
Yes.
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 After
Yeah, I think that.
Hello. Hello, in the matter on 22nd July 25, certain instructions short from the Learned Council.
Lordship, in this matter, I have received my instructions. I'll be filing my affidavit. And my lord, there's also an IA, I think, my lord. He has filed an
The party test. So far as his impleadment is necessary or not, my lord, let him file affidavit. Then, my lord, the question of impleadment is come. And even on this impleadment, my lord, I have some submission in this matter. If your lordship permits me, then today also I am ready on merit. My lord, in this matter, what happened, my lord? 2021, my lord.
I'll file my
Yes, better let him
better
file affidavit, my lord. That may be fixed. Yes, maybe 2 weeks may be given, but that may be fixed.
or
Sorry. Verbal.
or answer.
K.I. Mozumdar, my lord.
K I
Item number 20.
I'm respondent of 7 in this case, my lord, and petitioner in item number 23.
IA, my lord.
Learned nothing of the or that or dated second of
July.
2025 is correct and take the record by 10 and raise after week. There this after on
8. Yes, my lord, 10 September.
and in other matter
IA, my lord, in first case, my lord, 4498 for impleadment of party respondent. As number six.
here with the petitioner WPC number 4628.
I am, yes, my lord. I'm K.I. Mozambique.
I learned and the open for
Yes. My lord, all the state
Yes,
respondents.
yes.
all the state part and the data you
I'm not party in that matter.
not yet.
Yes.
Here also said the by
Yes,
Yes, common, my lord.
common, my lord.
It's a common,
Common, yes.
one affidavit only, both the cases.
burden state I
Common affidavit.
On 10th of September. 10th of September, my lord. I have filed by my learned friend, my lord, regarding his impleadment, my lord. That it will be decided. Okay, my lord, his impleadment decide only.
or sir age does not
Yes.
or the application under order 1 then both of the applicant are 8 in the or the night that the applicant by
Yes, my lord. Yep, yep.
My lord, in item number 23, my lord, there is an interim order.
That is the issue here, my lord. Since 2023, this interim order, they are enjoying by this land payment.
order passer
Bless.
My lord, in this case, matter relates to family pension, my lord. The petitioner governed by Mohammedan law, my lord. And admittedly, my lord, petitioner is the first wife. And my husband was serving as the assistant teacher of Pontim Dukijan Adult LP School under Nagaon district, who died on 10/5/2021. And I was the first wife. I am the first wife, and my marriage was solemnized on 12/12/1999. And the private respondent number 9 was married on 10/5, subsequently on 2011-2000. And as per the full bench decision of our High Court, the first wife is entitled for family pension. And as per rule, my lord. And that I am the first wife, as per my lord, there was a complaint case lodged by me against my husband in the year 2024, case 25. Against my husband for maintenance as well as the 498 application. And in that proceeding, the learned court below held that I am the legally married wife page 32.
Page what?
Hello? Page 25, this is the type copy, and original copy is from page 39. Is it?
25.
Yes, my lord. 25 onwards, this is judgment passed by the judicial magistrate first class against CR case number 481 of
How
2001.
did the order is related to the
My lord, in that case, my lord, the learned court held that I am the first wife, I am the legally married wife. I want to place you before your lordship that I am the legally married wife. My marriage was solemnized in the year 1999.
was that to the court?
My lord, now the private party has stated that there was no marriage between myself and my husband, and therefore all the pensionary benefit is entitled to the in the name of the private respondent. And even, my lord, there is a interim order passed. Yes, my lord.
Whether you are the first wife or you are the second wife was the learned court.
No, no. With regard to maintenance, my
Then
lord.
how that finding?
My lord, just I am placing that I am the wife. The learned below held that I am the accused had married the complainant, myself, my lord. Wife on 12/12/99, and
My lord, this is
I am
the
the considered opinion that
crucial aspect of the entire matter, my lord.
Pardon?
That regarding that, my lord, marriage of the writ petitioner to her husband, my lord, so-called husband, my lord. That is the main issue of the entire matter. So, my lord, that 498A would applicable, or that judgment would be applicable or not,
That was for a father.
my lord. It was cruelty by husband, but that husband, whether it is liberally, my lord, interpreted by Supreme Court or not, my lord, I will, my lord, argue on that, my lord.
Then, my lord, pays thereafter they have filed affidavit denying my marriage with my husband, my lord. And I have filed reply. And one of the document, my lord, page 93.
Open for appearing for
For
Private
private respondent 9, the wife, my lord.
the original wife.
My lord, as per my, my lord, person of the entire matter, my lord, I was the only wife of, my lord, my lord, I have forgotten the name. কি নাম আছিলে হাজবেণ্ডৰ?
Lutfur
Lutfur.
Hussain.
But the writ petitioner,
Yes, my lord. Page 93, this is the passbook, postal department passbook. My husband name has been reflected. In the year 2005. Yes, my lord. In the maintenance case also, my name has been reflected as wife.
Can that dispute be decided in a date from the dispute?
My lord, in the interim order, my lordship may please to peruse the page 95.
The order is there.
Interim order, the petitioner is the first wife of the deceased Lutfur Hussain, whereas the respondent number 9 is the second wife. The family pension had been paid to the respondent number 5 by the order impugning order. Under the law, prima facie, it would be the first wife who is entitled to the pensionary benefit. And considering the prima facie case being made out, the petitioner, and in view of the balance of convenience and irreparable loss that the petitioner may suffer, pensionary benefit be not given to respondent number 9 until further order. In spite of the interim order, some benefit has been released to the private respondent on in spite of that order. So as my humble submission would be that, my lord, I am the legally married first wife. My marriage was solemnized, my lord. That has never been disputed.
But observation there
Yes, my lord.
while crossing the order, but it's frame order.
Yes.
But at that time, the other side was not present and heard.
My lord, that also, my lord, there is an observation by the trial court, my lord. Your lordship may.
The whether such a can decide it.
Now the private respondent has raised such objection, my lord. The PPU may be issued in my favor. I will maintain, my lord, as per a full bench decision. There is a full bench decision. I have placed that judgment in the case of Junufa Bibi Mishti. Because PPU will be issued in the name of one wife. I will maintain, my lord. Paragraph 22 of the judgment and 23. When there are dispute with regard to two wives, then first wife will be entitled. If my friend is agreeable, my lord, then matter can be disposed of, my lord. Otherwise, both of us will be depriving. For last 4 years, my lord. Till today, I have not received anything.
The interim order was in your favor.
Yes, ma'am.
Now you are receiving the benefit.
No, my lord, nothing. Even after interim order, my lord, the PP was issued in the name of the second wife. But that has not been given effect. In view of my lord full bench decision, I am the legally married first wife and I am entitled to the family pension and I will maintain, my lord.
My lord, that full bench decision is applicable to, my lord, first wife, second wife, third wife, etc. But here, my lord, in this case, my lord, I am the only wife. My lord, I take your lordship straight to page 60 and 61, my lord, of my affidavit in opposition, my lord. 60, page 60, my lord, down below. That will clarify the, my lord, position. Affidavit in opposition filed by respondent number 9. Nurjahan Sultana, wife of late Lutfur Hussain. Running page 60 minutes. Married. Last parameter. Regarding the false claim of the writ petitioner that she is the wife of Lutfur Hussain, this deponent states that no marriage between Lutfur Hussain and writ petitioner was solemnized. In this context, this deponent states also that it appears from record that on 12/12/1999, a kabinnama was executed prior to the pronouncement of next page minute. Kabinnama was executed prior to the pronouncement of nikah formula, sigha, that is utterance of the words of proposal and acceptance of both the parties themselves or their representatives in each other's presence and hearing, and also in presence and hearing of the witnesses. Fraudulently, on 10/1/2000, the bridegroom submitted an application for cancellation of the said kabinnama, stating that the said kabinnama was fraudulently executed. Accordingly, the Sodor Qazi of the Muslim Marriage and Divorce Register Sodor Nagaon, by an order dated 10/1/2000, cancelled the said kabinnama number 464 under Rule 36 of the registry. The said order dated 10/1/2000 reveals that no marriage between Lutfur Hussain and writ petitioner was solemnized, and the kabinnama dated 12/12/1999, the document containing the offer in acceptance, executed before the utterance of the words of declaration and acceptance is void ab initio. As such, no marriage of the writ petitioner was solemnized with Lutfur Hussain, and accordingly the writ petitioner is not a wife of Lutfur Hussain since deceased. Now I take your lordship to page 72 and 73. The vital document, my lord, regarding the Qazi's certificate, my lord. It's a translated copy 72 and 73 in vernacular, my lord. My lord, I'm reading from page 72, my lord. Office of the Muslim Marriage and Divorce Register, Nagaon, reference number so-and-so, dated 10/1/2000. On 12/12/1999, last, Kabin Nama between Mohammad Lutfur Hussain, resident of Morangaon, Juria, and Mustafita Safizun Nessa, resident of GNB Road of Nagaon district, was executed. But the marriage was not read over and still have not been performed. Today, the bridegroom came to my office and submitted an application in my office stating that the said Kabin Nama was executed fraudulently. As such, on the basis of the above noted application, the Kabin Nama number 464 executed fraudulently without read over the marriage is cancelled under Rule 36 of the Marriage and Divorce Register 1935. My lord, now I take your lordship to that Rule 36, my lord. Assam Muslim Marriage and Divorce Registration Rule 1935. Rule 36. Page 666, minute. Down below, Rule 36. Refusal deferred. In cases 2, 4, and 8 referred to in Rule 35, then Rule 35 is regarding refusal to register, minute. The refusal order shall ordinarily be deferred till 1 month has elapsed from the date on which the marriage or divorce was effected. Now, it is important. It is relevant to this case, Miller. But if the parties declare their inability to comply with the requirements of the law, or for any other reason, wish that registration should at once be refused, this may be done. As per contents of this Rule 36, Miller, that order at page 72, Miller, it was passed. So, Miller, that marriage was not valid, but since, Miller, that 498A, section 498A of IPC, that judgment, Miller, has been relied upon, Miller. The Supreme Court said, Miller, that section 498A, that should be liberally interpreted. And for that, Miller, I am relying upon a judgment of Supreme Court, Miller. Only one judgment for that purpose, Miller. Rima Agarwal versus Anupam and others, 2004 3 SCC 199. Beautifully, Miller. Miller. Miller, the disputed question of fact, Miller, then Miller, it should not be entertained, Miller, this petition. Not maintainable, Miller. And regarding, if we go deeper into the matter, regarding that marriage is valid or not, that civil code will have to declare, Miller. And as per the Muslim Divorce and Marriage and Divorce Registration Act, Miller, section 25, only civil court has the jurisdiction, Miller. So no criminal court as per section 25, Miller, of this Muslim Marriage and Divorce Registration Act, Miller. 25. That was, Miller, rules, Miller. Now this is act. এখন এক আগৰখন rules আছে। Page 655, Miller. Only 2 lines, Miller. Nothing contained in this act or in the rules made under the authority of this act shall be deemed to affect the jurisdiction of the civil court. And as per this judgment of Supreme Court, Miller, regarding 498A, any judgment, Miller, passed by the criminal court, Miller, it is not, Miller, applicable, particularly in this matter. Miller, may I read those 3 paras, Miller? Miller.
We have let the party
Is not maintainable.
My lord, I am the first wife, I am the only wife, my lord. But the petitioner has stated that there is no marriage. My lord, page 72. My client has relied upon a document, page 72, that has been filed on the basis of an application filed by another person. Without hearing me, they cannot cancel, my lord. Page 72. On 12/12/99, so-and-so has approached the authority and filed an application for cancellation of marriage. Without hearing me, they cannot cancel, my lord. And if
that is not the selected.
my lord, if I am not a wife, my lord, how could I file 498 application? And in page 33, there was a observation, my lord. The Kabinama was registered in the Sodar Kazi office. That issue has to be raised on the first day, my lord. For last 4 years, it is hearing, my lord. But
we have entered appearance only in 2024, Miller.
My lord, in 22, on the basis of our submission, there is a stay order. And
Maybe.
you
Expertise
lordship,
stay order.
please peruse page 33.
Satisfied with that get the
There is no dispute. There is no dispute on my part, my lord. Now they have raised some dispute, my lord.
yes.
I am the wife. There is an observation by the trial court. There is a certificate. Certificate means, my lord, there is bank account stating that I am the wife of late Lutfur Hussain. Page, my lord, your lordship, place 93. Place 93. This is the bank account issued by the postal bank account, my lord. Mrs. Tokirun Nasa, wife of Lutfur Hussain.
The most vital document has not been produced by the writ petition, the marriage certificate. Where is the marriage certificate, Miller? If it is not there,
denied, my lord.
only relying only on the order of the criminal court regarding 498A. And Supreme Court is clear, 498A, while deciding any, Milord, question under 498A IPC, Milord, this husband-wife relationship is not, Milord, valid or not valid, Milord. It is still questionable.
Milord.
And that will be decided by civil court. Since, Milord, the writ petitioner could not produce the marriage certificate, which has been done by the respondent number 9. So I am the only wife, Milord, only, and that marriage is valid, Milord, and my name has been, Milord, indicated in all the service-related documents, Milord, in the service book also, Milord. I have 2 daughters, Milord, 1 grandchild, Milord, and I am without any pensionary amount, Milord, right now, Milord.
Page 93, that cannot be denied, my lord. I am the wife of
And the writ petitioner has not got any, Milord, issue, Milord.
Page 33, the Kabinama was registered in the Sodar Kazi and the accused himself admitted. Page 33. The trial court, my lord, page 33. The Kabinama was registered in the Sodar Kazi office is a fact which is admitted by the accused. That means my husband. And that Kabinama cannot be rejected on the basis of application filed by other person without hearing him. That was unilateral cancellation. And page 32, after perusing the evidence of PW, it appears that the accused Lutfur Lom Hussain had married the complainant. Then, my lord, another paragraph 33, last paragraph. I am of the considered opinion that prosecution has been able to prove that PW1 is the legally married wife. This judgment was passed in the year 2020.
Maybe for the purpose of
Maybe, my lord, but I am the wife, therefore that I have filed a petition before the criminal court. If I was not a wife, how could I file any application?
declare as the wife.
That is the observation, my lord. And subsequently, the postal department has also issued. Subsequently, postal department has also issued the bank account in my name, showing my husband as Lutfur Hussain.
As per section 35, the civil court has the ignored this act.
We cannot, my lord. Now my brain has disputed, my lord.
Or if not satisfied with that, the or disputed question of fact. Quickly carry on the point 19. Thereafter, both the medical art, normal art.
9.
KD. Number 3. And one and four. One and four. One and four. So they already so
My friend, can we send it?
my name is this the matter on
A very short date may be given, my lord. My lord, respondent number 9 with her family, my lord, is without any pensionary amount for last. Yes.
yes.
Matter we treated as partner. Most obliged.
M.A. Uja.
M. Dr. and four. Allowing her to make correct in the edit stated mindset right. Carry out the five as per order of stated 45 by then the learned have said in paragraph number
3, Your Lordship.
3 of the affidavit in opposition
In the interlocutory application, Your Lordship, at page 6, interlocutory application, Your Lordship, I have specifically specific correction I have about the printing mistake at paragraph 3, page 6. In my IA, Your Lordship.
Regarding the year on. Regarding the year on.
Only year.
Yes.
Only year. There is no change of nature, Your Lordship. Only the year. It is supposed to be 2024, but it has printed as 2004. That I have highlighted at paragraph 3, Your Lordship. In my additional affidavit. File on 9/7/2025.
that in the additional affidavit filed by the applicant, the number of the petition was inadvertently mentioned as WC 2003 2006 from 2004. That is for 165. 8 lines from the last. And at page number 168, 4th line and 3rd line from the last. And at page number 169, 11 line from the last. And 4th line from the top. And at page number 179, line from the last. State of WPC 2006 and the same equal to correct according to the price for allowed that they would go the yes number 3 yes and number 5 and subset in public. They have no object. The event of making the erratic the first collection as part of this interlocutory in the affidavit that submitted by the applicant on 9/7/2020. The earnest have file corrected that affidavit press edit affidavit in a period of 1 week from today. In terms of this, the main petition, what order it will be passed?
Here it is my petition pertaining to subsistence allowance, Your Lordship, and there is an preliminary order on 1/5/2024 of this honorable court. One 5/2024. The operative part is at last part, Your Lordship. Directed to release the subsistence allowances.
Whether that was released?
Not yet released. Not yet released. Another aspect has arisen here. Regarding the arbitrary order of suspension is completely arbitrary. Your Lordship, kindly come to page 57 of the original petition. That is the writ petition, annexure 11. That is the order, impugn order that I have assailed before this honorable court. At page 57.
The matter is not ready for hearing now.
Yes, yes.
Mr. Sharma, why you are not released this?
My lord, here actually matter is that my lord, when we come to the page number 43. Page number 43 of writ petition.
No, we will hear
Annexure
you.
8. Yes, madam.
We will hear you.
But my lord,
you first comply with the order of this court. You release the subsistence allowance.
but my lord, in 15/5/2013, one case is instituted by the respondent number 6, WBC number 2553/2013, where my lord, the petitioner's provincialization was withdrawn by the honorable court, directed and accordingly withdrawn. Here it is mentioned, prior to this, the respondent number 6 also preferred a writ petition being WPC number 2553/2013, in which page number 47 of the main writ petition.
Yes.
Paragraph number 3, in which the court, by its order dated 15/5/2013, issued an interim order restraining the respondents therein from provincializing the service of the writ petitioner of WPC number 516/2016. The writ petitioner 516/2016 is present petitioner, my lord. Surya Khatun, as junior assistant in the said Montessor High School, and considering that fact, the court on 13/9/2013, while issuing notice to the respondents in the said petition number so and so, observed that benefit of provincialization to the petitioner in WPC number 516 as junior assistant of said Monang High School, district Dhuburi, should not be granted.
If that is your case, then how can you place them under suspension? Annexure 11.
Now she is not our employee. So in our affidavit also it is mentioned. The answering the paragraph 8.
But how can this order came to be passed?
So regarding
If he is not your employee,
yes, now the matter is pending before the educational tribunal. Here in the court order, it is also reflected in page number 51, my lord, of the writ petition.
No, no, whether you have to on that point.
Yes.
Tell me if it's not your employee, how this order came about.
Regarding that, my lord, I have to take. Yes, regarding that, I have to take instruction.
No, in
I have
fact,
to take-
file your affidavit.
Yes.
Instruction is accepted.
So regarding that, it is not mentioned here. Yes, my lord, it is as per Deputy Commissioner's report, I just suspended. Here it is paragraph 4 of our affidavit. That the Secretary to the Government of Assam by letter so and so directed the Director of Secondary Education to place the delinquent.
Comply with the order of the court dated 1/5/2020. So if release the substance, only thereafter we will hear it, not other. Third, the third, the third. Then, Norma. Second state. The third. Order. Order. 1/5/2020. That I third. The court particular heading page the third order delay. But to the order was passed 1/5/2025, then 1/11, then the number has not been complied with the order of this court. Accordingly, taking the submission of the attorney, it is provided that Mr. Verma furnished computer for that pay the submission of as per law in a period of
My lord, 4 weeks may be granted, my lord. My lord, 4 weeks may be granted as because she
going
was already deprovincialized.
not comply with the order for more than 1 year. Did you file any review petition against this order? No. Are you aware of this order? No. Or you let your respondent number to remain present.
My lord, one chance may be granted. Actually, in that order, H. Terengpi was there. Not I am not there, my lord. So I don't know whether she communicated to the department or not, my lord. So
We are not concerned with that. We are concerned with the compliance of the order of this court. In a period of from there, let's say the term of 15 September, in the event of failing if the order the court has considered, directing the respondent number present the court part is set.
My lord, first of all, I tender my apology. I was the one to have prayed for upgrading. I was stuck, my lord.
May please, your lordship. No, this is basically a matter wherein the petitioner is aggrieved by an order of the additional session judge. Lord, what happened before, my lord, taking your lordships with the papers, I'll just place the facts, my lord. Lord, what happened in this matter? Respondent number 4, she was placed under suspension by the disciplinary authority in contemplation of a departmental proceeding. Lord, show cause notice was issued. The show cause notice contained, my lord, 8 charges, statement of allegations, then list of documents and list of witnesses.
she submitted an application asking for the copies of the document and Xerox copy of the document. The disciplinary authority said, no, Xerox copy is not permissible. Look, you can inspect the document. She inspected the documents and thereafter she filed her reply. After that reply, after filing reply, my lord, the disciplinary authority was not satisfied with the reply and decided to go for inquiry. Now, the inquiry, my lord, 4-5 days, the inquiry was fixed. She never participated in the inquiry, despite receipt of notice issued by the Millard Inquiry Committee. Then finally the inquiry was held ex parte and the charges were held to be proved. The inquiry report was communicated to her. She did not file any reply to the report of the inquiry officer. The disciplinary authority, my lord, having no alternative, my lord, took into consideration the inquiry report and imposed penalty of dismissal from service. Now, after the penalty was imposed, my lord, she filed an appeal before the educational tribunal challenging the suspension. During the pendency of that appeal, she could come to know that there is a dismissal order also. So she wanted to amend the appeal and, my lord, she amended the appeal. Along with that appeal, she filed a petition praying for production of documents, my lord. Those documents has got no relevance with the merit of the dismissal or suspension. The additional session judge, my lord, by an order rejected that petition, giving sufficient reasons for that rejection, saying that those documents which you have asked are not relevant and there is no requirement of those documents. On the eve of transfer of the judicial officer, she filed another petition praying for the same, making the same prayer. And on this time, my lord, another judicial officer joined after the transfer of the previous officer, and that officer passed an order without assigning any reason that, my lord, the documents, so and so documents are to be produced and furnished. My lord, this final order, last order, is under challenge in the present date petition. That is briefly the case, my lord. I'll just take your lordship with the papers, documents annexed here. Lordship will kindly come to page 24.
Yes.
This is the suspension order, my lord. 2/1/2021. With reference to the subject quoted in the caption, I would like to inform you that you are placed under suspension with immediate effect under proviso to section 15(2) of Assam Non-Government Educational Institution Regulation and Management Act 2006, read with section 17 ABF of the Assam Non-Government Educational Institution Regulation Management Rule 2007. The disciplinary committee has already been formed, which will conduct the inquiry in respect of the charges involved in the departmental proceeding drawn against you. During the period of suspension, you are not to attend the school until and unless required for the purpose of conduct of the proceeding that is contemplated against you. Now, after this, my lord, page 25 is a show cause notice, my lord, dated 30/3/2021. My lord, there are 8 charges, my lord. I'll just read very fast the charges are. Although these are not, we are not concerned with the merit of the DP. Also, will kindly appreciate the my lord, gravity of the charges. Number 1, that you, without any authority and with malafide intention, prepared an appointment letter dated so and so on the letterpad of the school by forging the signature of the principal of the school, showing yourself to have been appointed as assistant teacher of the school. By referring to a non-existent resolution of the managing committee of the school, the existence of the said appointment order was not to the knowledge of the authorities of the school till recent past. Further, by utilizing the fake appointment letter dated so and so, you have resorted to misrepresentation before the Guwahati High Court in WPC number so and so, instituted by you to plead that you have been in service of the school with effect from so and so, which assertion is clearly perverse. The forgery made by you of the signature of the principal of the school in the appointment letter dated so and so stood established upon forensic examination of the same. The above act of yourself reflects an malafide intention and upon your integrity. The forgery resorted to by you for achieving your nefarious intention was undermined the reputation of the institution. As such, by your above conduct, you have acted dishonestly and in the manner prejudicial to the interest of the school. You are therefore charged with gross misconduct, forgery, insubordination, misrepresentation, dishonesty, for unbecoming of status of the school, as well as the provisions of Rule 24B2 of Assam Non-Government Education Institution Regulation and Management Rule 2007. Second charge, that from the RTI replies as received from the authorities of IGNO, it is revealed that you had submitted an application before the authorities of IGNO for pursuing B.Ed course, and therein had projected that you were working as assistant teacher in Emmanuel English High School, Pailapul, with effect from 95, and had submitted an experience and employment certificate required to be furnished along with and in connection with the said application by forging the signature of the principal of the school therein. The forgery made by you of the signature of the principal of the school in the said application form, and also the experience and employment certificate required to be submitted in connection with the said application form stood established upon forensic examination of the same. Now, charge number 3, that you, by misusing the trust reposed on you, prepared fake appointment letter dated 10/1/2010 by forging the signature of the principal. This is charge number 3. Then, my lord, charge number 4 in page 28, that the RTI replies received from IGNO has revealed that you had, for the purpose of securing an admission for your husband into B.Ed course conducted by IGNO, by misusing the trust reposed upon you, concealed the fact your husband was not eligible for B.Ed course as he did not fulfill the eligibility, i.e. minimum 50% marks in graduation, which is evident from his B.Ed application form. This was allegation number 4. Then 5, proceeded to issue further experience cum employment certificate in favor of your husband on so and so and so and so, projecting yourself to be headmistress of the school, utilizing the school seal without authority. Then, my lord, page 30, charge number 6, that from undertaking given by MS so and so, it is revealed that you had without authority and by taking undue advantage of the trust reposed upon you, issued to them appointment letters showing them to have been appointed and working in Emmanuel High School for the purpose of securing admission into B.Ed program conducted by IGNO. She gave certificate to another person also for getting admission in B.Ed course. Then page 31, serial number 7, you had, in clear derogation of the norms of the management of the school, tried to create a parallel management in the school, and with this intention, in connivance with few members of the erstwhile managing committee of the school, convened meetings of the managing committee outside the school premises and adopted resolution with the intention to take control of the school management. Then page 32, charge number 8, you, without any authority and by resorting to forgery, had got illegally rectified the land documents standing in the name of Emmanuel High School, Binakandi, to that of the Moirangthem Deb Singh Memorial Academy. The land covered by Doug number so and so, deed number so and so, deed number so and so, brought and standing in the name of Emmanuel English High School, Binakandi, were illegally changed to that of Moirangthem Deb Singh Memorial Academy by falsely projecting that there was a typographical error in the original deed. You were actively involved to change the name of Emmanuel English High School, Binakandi, to Moirangthem Deb Singh Memorial Academy by projecting that the same was done under the instruction of the Inspector of Schools, CDC Silchar, and basing on such misrepresentation got the sale deed modified. So these were the basic, Milord, 8 charges. Milord, statement of allegation, Milord, is a replica of the charges, Milord. I will not take your lordships.
Order.
Yes, my lord.
Page number.
Impugn order is at page 67, my lord. Prior to that, your lordship would like to see the first order, page 65.
Yes.
Page 65, present the learned judicial officer A.J. Bora. Both parties are represented. Petition 80/3 pertains to appellant's prayer to call for the relevant records and documents from the respondents. Peru Sierra heard both learned counsels. The present appeal concerns with impugning the suspension and dismissal of the appellant by the respondent by order dated so and so and so and so respectively. So far as direction to respondents to produce the documents as mentioned in schedule to the petition 80/3 is concerned, I am of the opinion that the appellant has not tendered any cogent explanation as to why such document pertaining to year 1987 to 2015 are required, when prima facie it will be of no aid to the appellant vis-a-vis his alleged suspension or dismissal. No explanation is also forthcoming as to why such whole documents sought to be called for are necessary for the purpose of this appeal, without which the adjudication of this appeal is not feasible. For the foregoing reasons, petition under petition 80/3 is rejected. Nonetheless, call for the original records pertaining to suspension and dismissal of the appellant from the concerned respondents. Appellant takes step fixed on so and so. So this was the first order passed, Miller, rejecting that those documents were not required. But the learned court had held that records pertaining to dismissal and suspension, which we normally know the records of the departmental proceeding, like that of the inquiry report, evidence collected, deposition of the witnesses, those were directed to be produced. After this order is dated, my lord, 15/11/2021. On 25 April 2022, just on the eve of when the concerned judicial officer was under an order of transfer, there is an order also, Miller. I'll just refer to that order. This petition was filed asking for the same very documents, that the respondents, despite order to produce all original documents relating to suspension and termination.
That order is the page number?
This is the petition, Miller.
Okay.
Page 66, Miller. I'm sorry. Yes. That the respondents, despite order to produce all original documents relating to suspension and termination, have not submitted original minutes book, 2 books for the period 87-15 and 1 book from 15 till date, salary and attendance register for period 93 to 97, report register of KG2 for years 1995, school magazine published in 2000, and all original correspondences, though referred in the papers relating to suspension and termination of the appellant. In the absence of those documents which are lying in the custody of the respondent number 4, the appellant will be unable to prove her contention made in the appeal. For the ends of justice, it is therefore necessary to direct the respondent number 4 to produce the above documents. So what are the documents she asked? The humble appellant prays for Your Honor, may you please to direct respondent to submit original minute book, salary, attendance register, report register of KG2, school magazine, etc. as stated above, so and so. These are the documents which she asked in the previous petition 80/3. That was rejected. And the subsequent judicial officer, it was the responsibility of the respondent number 4 to bring into the notice of the honorable court therein that already this order was passed. This impugn order was passed at page 67. Both sides represented the petition so and so filed on so and so has been pending for order. I have heard learned counsel for the appellant, and it is desirable to call for the records relating to suspension and dismissal of the appellant from the respondent 4 for the purpose of the disposal of this appeal. Let call for the original minute book, salary and attendance register, report register of KG2, school magazine, etc. as prayed for in the petition number 25/1. Milord, we are aggrieved by this last paragraph. So far as Milord records pertaining to suspension and dismissal is concerned, we don't have any problem to produce. But taking a clue from that line of the previous order, which starts, nonetheless call for the original records pertaining to suspension and dismissal of the appellant from the concerned respondent. They have filed a subsequent petition saying that these documents which were rejected earlier by the learned tribunal will again have to be produced, and the learned court below, Milord, committed that mistake, Milord. It's clearly hit by the principles of res judicata, Milord. Apart from other requirements, whether these are at all relevant or not, Milord. If I just take your lordship to the show cause notice list of documents, page 42, total 20 documents were there, page 42 and 43. These documents were relied on by the disciplinary authority to prove the allegation against the respondent number 4. So the documents pertaining to suspension and dismissal referred to by the learned court below in the first order would be the documents, these documents, and deposition of the witnesses, if any, or if any witnesses produce any documents, those will be the relevant documents. Now, your lordship will kindly see how the respondent number 4 had conducted herself in the inquiry. My lord will kindly come to page 47. We'll have one fact in between. I'll just place page 46. If your lordships kindly come, say ask for a photocopy of the documents, then the disciplinary authority said you may physically come to inspect the documents and take pencil note of the same. You may come on so and so between so and so and so and so at the school office. Then she came on that particular day, 13/4/2021. She came and she inspected the documents. Thereafter, she filed her reply that is dated 18/4/2021. Then the enquiry started. Lordship will kindly see the conduct during the course of enquiry. Page 47, by which it was communicated to her that your reply was not satisfactory. However, as the reply filed by you is unsatisfactory, this is to intimate you that an inquiry into the charges is called for. A disciplinary committee has been formed. Sri so-and-so has been appointed as presenting officer. Thereafter, page 48 is the notice of the departmental proceeding, my lord. In reference to the subject cited above, this is to inform you that the next date of the preliminary hearing has been fixed on 12th June 2021 at 11 a.m. You are hereby requested to attend the departmental proceeding on the given date and time, failing which the proceeding will be taken ex parte. Further, any communication from your end to the committee be made in the official email address so and so. So this was, my lord, sent page 49. Item delivery confirmed. She did not appear on 12/6/2021. Then page 50, my lord, will kindly have a look. Next date was fixed, that is 19/6/2021.
That's right. But does
Yes, my lord.
document order it first?
Yes, my lord. My lord, why I am referring? Because lordship will appreciate one aspect. The issue before the learned tribunal is suspension and dismissal. She challenged the merits of her suspension and the dismissal order. Now, if we go by the principles of, my lord, concerning the departmental proceeding, the stage for asking documents is during the course of inquiry itself. You chose not to participate in the entire inquiry. Inquiry report was communicated to you. You did not file a reply to that. Now, while after filing of the appeal, I'm sorry, Milo. Yes, ma'am.
If I find the
Yes, Milo.
right?
Yes.
And the order passed by the tribunal
Yes.
was presided by one official of
Correct.
its capacity as
As a educational tribunal, Milo.
whether against a judicial order passed by a tribunal, the reasoning
My lord, this, although additional district and session judge, passed the order, but this was passed as a presiding officer of the educational tribunal. And this court has got the supervisory jurisdiction upon the
26 and 27 are bhag pare. There are bhag pare. It is not under 27. Tell me whether
I'll
the order passed by a tribunal. It is under article.
similar question came in another matter before the division bench, for which Miller I did some research on this topic. Whether this even after not writing 227 will dilute the very purpose of the petition, Miller. That question, Miller, so far as I remember, was answered favorably. But right now, Miller, I have not brought that judgment. Because the only difficulty is that I have this petition, it was not written 226/227. Whether not writing 227 will frustrate the petition, because supervisory power your lordships have.
If we exercise the jurisdiction under article 26 again, order,
Yes.
then the other party may go to the Supreme Court. And the Supreme Court
Because
you see the
say for example, Milord, in Assam Administrative Tribunal, the when we file matters before the Assam Administrative Tribunal, if any decision of the tribunal comes challenging that tribunal, Milord, we approach the writ court, and it comes up before.
there is no problem.
But here, although the Milord, subject to your lordships, although he is the learned member, he is an additional district and session judge, but he was acting as a member, as a presiding officer of tribunal. In that event, Milord, your lordships has got the power. But I can satisfy your lordships in detail in this Milord question. Milord, it's a valid question. Milord, it's a valid question.
I will go to the merit of the.
Fine, my lord, fine. Since question has come to your lordship's mind, my lord, I must satisfy your lordship's. Yes, my lord.
We have to decide whether
Exactly, my lord. Correct, my lord. Correct. I'll satisfy, my lord.
or
আমি judgment কথা ওলাইছিলো যে এই নমলি ঘর
property number
4 man.
4. That for all 4 number. What?
Will not be provided.
It's the matter on first enable the current website regard of it of that against the order passed by additional district judge, district and state judge in or E or A
As a presiding judge.
in his capacity as educational
Tribunal.
it's according.
But 16, some difficulty, my lord. 16, yes, my lord. Can it be on, my lord? 23, my lord.
But it's already
23rd of September.
23rd of September.
My lord has heard it. My lord will be keeping this part. My lord.
Fine. Fine. Deeply.